This is our town. For 150 years, the home of Jack Daniels. If you can't get here, just look for one of our postcards. We send them all over. They look like this.
That is a Jack Daniels ad, and as you can see, right there is a Jack Daniels bottle. We wanted to have a Jack Daniels bottle on the set, but thought better of it. Never good to drink alone. This, on the other hand, is a dog toy, specifically a bad Spaniels dog chew toy. It is perhaps hard to confuse the two, but now the Supreme Court will decide just how similar they are. No, seriously, this is now a Supreme Court case to decide a dog chew toy versus a Jack Daniels bottle. Only in 2022. Lawyers for Jack Daniels argue providing near blanket protection to humorous infringers undermines Congress' goals, creates disuniformity, and rewards forum shopping. Attorneys for the toy company say, in playful, parodic tradition that has ranged over half a century, we put out a chewable dog toy. Tom Dupree is here, a constitutional attorney, former Deputy Assistant Attorney General under George W. Bush, and has argued countless cases before the High Court. Have you ever had one involving a dog chew?
This is a great issue, Leland. I personally haven't argued this issue, but I've been following this case pretty closely. As you said, it's really kind of a clash of absolutes. On one hand, you've got federal trademark law, which protects Jack Daniels and its brand. But on the other side of the equation, you've got the right to create parodies. And I think the argument of the dog toy manufacturer is that no one's going to confuse a bottle of whiskey with a dog chew toy.
I take it, so you would rather, if you had to pick, and assuming both would pay their bills, you'd rather take the dog chew side of this?
Well, you know, look, I'm both a Jack Daniels drinker and a dog owner, so I've got split loyalties here. And my hope is that the Supreme Court, however it resolves this case, will come out with a clear line for lawyers and for businesses to understand about how far you can go in the area of parody before you cross the line to being unlawful.
Right, but even in trying to read the lawyerly language about this and then realizing it's about a dog toy that's a spoof, we see there Smella a paw knocking off Stella. We've got the one that was luxury bag maker Louis Vuitton sued the makers of Chewy Vuitton in 2009 over their plush dog purse toy. No one was going to think a Chewy Vuitton was a Louis Vuitton. At what point does people have a right to sort of trade off the goodwill of a clearly very valuable trademark?
Right. Well, on one hand, you can't do it if there's the risk of customer confusion, which may not be present in this case, as you pointed out. But that would be one thing you can't do. The other thing you usually can't do under the law is use someone's trademark in a way that degrades or dilutes or diminishes the trademark. And so I suspect the Jack Daniels folks will say, well, wait a minute, you know, this is kind of a dog chew toy. It's got kind of a dog poo theme going on here. And this kind of diminishes the Jack Daniels brand in the minds of Americans.
And is it really that now the Supreme Court gets to decide whether or not the bad Spaniels whiskey dog chew actually diminishes the Jack Daniels brand?
Yeah, I think they're going to get into this. Now, look, the Supreme Court doesn't find facts, right? That's what a trial judge does. That's what a jury does. So the Supreme Court's not going to be out polling Americans about, are you getting confused or do you think this diminishes the brand? But what they are going to do is figure out what the governing rule of law here is and do their best to articulate a standard so that product manufacturers will understand kind of how close they can get to an established trademark before they cross the line.
I would love to be in chambers for this discussion, just saying, to being a fly in the wall. But real quick, you know, this also sort of goes into another realm, which is now all of the edibles and marijuana knocking off all of the candy manufacturers. You know, Carnaburst versus Starburst gummy sours, those have THC. Crunch berries as well. Nerds that were actually with THC. And these aren't sort of backyard manufacturers. These are actually companies making this stuff. There's a whole different line here, right?
Yeah, and look, the ruling in the Jack Daniels case is going to have broader applicability. I mean, it's obviously going to govern products other than Jack Daniels whiskey or dog toys. And so I think all manufacturers, including those, as you note, who kind of try to play off an established brand or the look and feel of a brand and kind of getting close to that line without crossing it. So they're all going to be looking to this case for guidance as to kind of how exactly they can mark their products without bringing on a lawsuit.